game.
Hey, how y'all doing? It's Big John. Welcome back to another episode of It's All in the Game. So, today, I want to talk about something that I have been meaning to talk about for a very, very long time. And that is the police's ability to listen to your phone conversations. The police's ability to wiretap your phones. Alright? So, there's a lot of misinformation about this out there, a lot of misunderstanding, a lot of paranoia. First and foremost, what I'd like to say to you is please be careful whenever you are talking on the phone, okay? Never assume that you are not being listened to and that it is totally safe. Always be careful about what you talk about on the phone. That being said, it is much more difficult for the police to listen to your phone calls than most people think it is, alright? So what we know as a police wiretap is controlled by a federal law called the Title III Omnibus Crime Control and Safety Act of 1968. And what this says, first and foremost, is in order for the police to listen to your phone calls, a law enforcement officer has to go to a prosecutor. And now there are only certain state and federal prosecutors who qualify to make this argument to a judge. And there are only certain state and federal judges who can hear wiretap arguments and issue wiretap warrants. All right? So, the police have to go to the prosecutor and make this argument that they need a wiretap. They have to show, all of their probable cause, and they have to show what is called exhaustion, because this is what the prosecutor is going to have to show to the judge. Now, what exhaustion means is that the police have tried other ways. The requirement is usually 3 ways. So the police have to have tried at least 3 other ways to arrest you or to get the information needed to prosecute you before they will authorize a wiretap. Because a wiretap is a huge invasion of somebody's privacy. So what that means is that they had to maybe come and try to buy drugs from you, but you wouldn't sell them. So then they sent somebody to, infiltrate their organization, but the organization was too tight and they could not be infiltrated. And then maybe they tried to, do surveillance. They tried to follow people and take pictures, but again, the organization was too tight and they could not be caught through surveillance. All right. So those would be 3 examples of exhaustion. And that is what the police and the prosecutors have to prove, that they need to make this huge breach in someone's personal liberty by allowing the police to listen to their phone calls. All right? So now once the judge has heard this argument, the first part of the argument is that there is ample probable cause that these people are committing a crime. By authorizing a wiretap, there is a good faith belief that they would be getting the information they need to convict this person of this crime. And the second part is exhaustion, that they have tried to bust them in a certain number of other ways and been unsuccessful. So they need to issue this wiretap. If the judge agrees with this argument, they will issue the wiretap for 30 days. They'll never issue one for more than 30 days. Every 30 days, the police have to go back and make that argument again. But if the judge granted one for the first 30 days, it's almost unheard of for them not to extend it for more time than that. Once the judge has issued this warrant and the police can now tap your phones, what they need to do is they need to literally have somebody monitoring your phone 24 hours a day. All right? So they need to have somebody there by the computer ready whenever you make or receive a phone call. All right? They can't just record all of your phone calls and then go back and listen to them later. They are only allowed to listen to phone calls related to the criminal investigation that is ongoing. I don't know if you all have seen that movie Goodfellas, but remember in the movie Goodfellas when Ray Liotta's character says, The cops listen to your phone call for 30 seconds, and if you're not talking about, criminal shit, they can't listen anymore. So basically what he would do is they would just talk about ordinary everyday shit for the first 30 seconds or minute they were on the phone, because they knew the cops had to hang up after that, and then they would talk about the dirt. And that is absolutely the way the law works. So if they determine that it is a non-pertinent call, that it's not related to the investigation, they have to hang up, and they can check back again in another 2 or 3 minutes. Different warrants will specify different lengths of time. So somebody has to be listening 24 hours a day, and they have to determine in the first 30 seconds or so whether or not this phone call is relevant to their investigation. And if it is, in that instance, the police will record the entire phone call, and they can use any and all information they glean from what is talked about in the case being made against that person. All right. Now, another thing that I hear sometimes in the street, somebody says, well, I talked to somebody who's, a pretty big player, and maybe their phone's being tapped. So, if they hear me on their phone, then they're going to tap my phone too. That is almost never, ever, ever going to happen. If the police hear you talking to someone who is the target of a wiretap investigation, they will almost assuredly use that information against you, and quite likely use it to try to leverage you against the person whose phone they had initially tapped. It is almost never, ever going to be the situation, though, where they actually tap your phone as a result of hearing you on that wiretap. If you are a smaller fish down the ladder, the only thing that they're probably going to get by tapping your phone is smaller fish, and that is not something that they're going to use, their resources on. They will absolutely use what you say against you to prosecute you. All right, so do always be careful about what you say on the phone. So that pretty much covers the laws surrounding the Wiretap Act of 1968. Other methods of electronic communication that I'm going to talk about before I wrap it up here, like texts and emails. A lot of times people think it is safer to text than to talk on the phone. This is absolutely not true. All right, so these kind of communications are dictated by the Electronic Communication Privacy Act of 1986, all right, better known as the ECPA. All right, so the ECPA says the police need a warrant, which can be signed by any judge, and if they get that warrant, they can take it to a service provider, and they can get your records for up to 180 days, meaning the police get a warrant, and they need just the most basic probable cause for the judge to believe that perhaps you are committing a crime. They take that warrant to Verizon, they can get all your texts from the last 180 days. Or they take it to Google, they can get all your emails, saved drafts of emails, deleted drafts, deleted emails or texts, anything that's been deleted. Anything that you have typed over the last 180 days, they will have access to. So this is something you need to be very, very careful about, all right? And the final bit of electronic communication I'm going to talk about are your phone call records. So the records of who you have called and when, or who has called you. And this is the absolutely least protected of all the things we're talking about today. This law is governed by a Supreme Court ruling in 1979, which said that the only thing the police need is a subpoena. All right, so the police just need to go to the judge and say, "Judge, we need a subpoena." And all a subpoena really is a fishing expedition. There is no standard for probable cause. All they need to do is say, "We're looking for probable cause, so please issue us a subpoena," and they will take that subpoena to a service provider, and the service provider will provide them with all the records they want of, your phone calls to and from your phone. So be aware of these things, y'all, okay, because, again, I do not want to make it sound like it is ever safe, to just talk freely on the phone. Always be careful. But in summary, it is very, very difficult for the police to listen to your phone calls, and it happens much less frequently than people think. All right? But as far as text messages and emails, this is something that's very easy for the police to access. Be very, very careful. And just be aware as far as who you're calling, who's calling you. Again, these are even easier for the police to access. If you guys like this video, if you guys like this content, click that like button. All right? And please, please click that subscribe button. I'm trying to build a team here, And I really appreciate all the support. And if you guys have advice or you guys got topics you'd like me to talk about, leave them in the comments. I read all the comments, all right? Take it easy. Big John told you so. It's all in the game.